You're off talking to the Harrows guy. We know it.
So, Anne, we're going to start with you.
Do you want to?
after I
Okay.
do introductions, because that way you can do your PowerPoints,
Right, okay.
and then we can,
So we can
is that okay?
Get on, yeah, that's fine.
Fabulous. This is just so fabulous. I'm having so much fun. So what we're going to do now is, after I briefly introduce our panelists, we're going to begin with Anne McGinley because she has PowerPoints, which I'm very excited to see. This is one of the few times I'm actually excited to see a PowerPoint presentation. I thought they might be pictures. And we're going to try and stay on schedule so that we don't starve you to death, because lunch is scheduled to begin at 1, which is late for some people for lunch. Okay, so we're going to begin with, if I had to identify the theme of this panel, notwithstanding our reluctance to actually have them, I would say that if the last panel was messages from the world of business, this is the panel of messages for everybody who wants to talk to lawyers about things other than just legal doctrine. And so we have Anne McGinley from UNLV, who actually knows a little bit about identity, performance, and sex in the casino business in Las Vegas from having studied it in an empirical way, meaning, you know, walking out of her office and into a casino and looking around, interviewing people, talking to people, finding out what actually really happens. And then we'll have Lucille Ponte and Jennifer Gillan. Did I pronounce Gilan?
Gillan.
Gillan.
And Ponte.
Ponte. Talking, Jennifer is in the English department and business school at Bentley College. I love that combination. Perhaps an unusual combination. And Lucille in the criminal justice and legal studies program. And so talking about body art. And then we will have, and it's not just people who aren't lawyers, then we actually have a real lawyer, Jenny Pizer, whom I've known for many years, and I'm thrilled that she came in from LA for this, who represented Darlene Jesperson on appeal. And I'm keen to hear what she has to say, although I'm not going to make you defend the pictures on the website, although, of course, we all want to know the answer to Mike Selby's question, not that you maintain the website. Julie Seaman, whose paper is one of the very few papers I've ever read that talks about legal doctrine from the perspective of sociobiology, where I actually thought, wow, this is really interesting, instead of, you know, the biologists ought to stick to studying animals and leave the law alone, because when they try and talk about, or when the lawyers try and talk about biology and deduce legal rules, it's just idiotic in my opinion. But when you start talking about power, then I get excited. And then Pat Shin from the perspective of philosophy.
Well, I just want to thank everybody for inviting me here, especially Catherine and me too. It's been exciting, a very exciting day. I wrote a paper called Babes and Beefcake, as you can see, exclusive hiring arrangements and sexy dress codes. I'm not known for boring titles anyway. One of the things that started to become very clear to me when I first got to UNLV, I sort of was denying that I was there. You know? It was sort of this idea that I can't believe I live in Las Vegas. So I had nothing to do really with the Strip or, you know, what was going on. And the more I started talking to my students, I realized that I wasn't, that there was this incredible laboratory outside there for me to go in and find out why I was in Las Vegas and what Las Vegas was all about and what the gender issues were. And one of the things I realized was that my students, it was a class issue. And my students, if I were to look down at people for getting dressed in skimpy costumes, I mean, it just was totally wrong, because so many of my students had to dress up as cocktail waitresses in order to be able to afford law school. So I thought, and some of them were exotic dancers, and although they might not be revealing themselves, there might very well be a prostitute or two in the group. So then I started writing about sex and sexy dress codes and sexual harassment. So I'm going to move from here. The cocktail service is what I'm talking about today, and that is in Nevada, in Las Vegas anyway, the cocktail servers who are hired, they're exclusively women. They have a particular look. well, not every place. The Hilton is known for having old cocktail waitresses. But anyway, usually in most of the casinos that are considered hip, they're young, thin, and sexy. They're dressed in sexy uniforms. And their job is to serve the customers with a smile. There are very strict regulations about what they can wear. Here's some examples. To the left, we've got the Hard Rock cocktail waitresses, the top on the three. And then the Caesar's Palace one is quite covered up, the white outfit. And then I don't remember where she's from. And some of the ones on the bottom, the one on the second to the right is Paris. She's supposed to be French. And then the one to the left of her is an Ipanema girl from the Rio. Where actually, this is interesting, at the Rio, they've changed it from being cocktail waitresses, they're called bevertainers. And the reason they've done that is that they were able to fire all the old kind of paunchy cocktail waitresses and make them interview by dancing. So part of their job is to dance and put on a performance. So in any event, you can see that they're all fairly young and they have a particular look. Breast implants are very big in Las Vegas, and there are employers, I don't know if Harris is one of them, there are employers who actually pay for those breast implants. But I mean, to be fair to the employers, some of the employees really like it. They make a lot more in tips this way. So it doesn't go all one way. Okay, a couple more cocktail waitresses. This one from Mandalay Bay on the left. I don't know where she's from, I can't remember. Okay, so here are the regulations. They have to wear the sexy costume. Often, this includes certain kinds of underwear, like push-up bras. I interviewed cocktail waitresses who told me that where they were not permitted to wear sweaters, even though they were freezing on the floor, because it's kept very, very cold there. And they had to wait for 1.5 years until the particular casino made jackets for them to wear so that they could wear little skimpy jackets over them because they had to be uniform. There have been fights over high heels, and some of the cocktail waitresses have won those fights to a certain extent. Most of the places have a requirement of 2 or 3 inch rather than 5 or 6 inch heels. Almost all of them, I think, require them to wear makeup, and their hair must be curled or styled. As I said, often employers will pay for breast implantation, and some women like it because they earn more in tips. One of the problems is I did a study on the Hard Rock, and a lot of the cocktail waitresses are particularly problematic because there's a lot of sexual harassment. But my sense of that is that the Hard Rock and other places that have a very especially high sexual energy, Hard Rock and the Palms are the ones that advertise for that, need to be more aware of what their customers are doing. I'm saying sexual harassment is by customers, and they need to make sure that their customers are not acting up. But the point that I was making before is some of these cocktail waitresses can make $75,000 or $80,000 a year. I mean, this is a good salary. It also provides, for some of them part-time work so that they can go to school, so they can actually flourish. Many of our law students have been cocktail servers. Okay. Now, some of the employer intents at keeping them sexy are sort of interesting. One of the casinos, which I think has since been taken over by Harrah's and probably does not have this rule anymore, I've heard it doesn't, I'll have to ask Paul about it, had contracts with women employees, that they could not gain more than 6 pounds from their original weight or they would be laid off, and that actually happened to a student of mine. At that same place, there was a pregnancy discrimination lawsuit, and in response to the pregnancy discrimination lawsuit, the casino changed the uniforms so that the belly would be exposed so that no one who was pregnant would want to work there. So, I mean, they said women who were pregnant could do this job, but no one who was pregnant would want to work there. And then in another one, the Rio, they laid off older workers, and hiring of younger bevertainers has happened, and they require that they sing and dance. Another rumor about that is the other reason for doing that was to break the union because the bevertainers they hired were not union employees. Okay. Some of the casino employers' views that the cocktail servers are beautiful. They represent the essence of what Las Vegas is. It's a glamorous illusion. The men come to see the cocktail servers, and I've talked to some of my male colleagues, and what they say is the thing that's best about them is that they don't have any needs. I love this. The cocktail servers have no needs, and women are so irritating because they have needs, so this is why they're... They operate in a bubble of fantasy, and the casinos would be drab without them. They very well might be. Okay. Now, interestingly enough, there's another job that's usually exclusively male, and that is casino hosts. These guys go around and they entertain the high rollers, who are the people who spend a lot of money. They buy them tickets for strip shows. They take them to the restaurants. They take them to the strip shows, and interestingly enough, they do better than the cocktail servers. In some of the casinos, I've had cocktail waitresses complain that actually the casino hosts are taking some of their tips because they get a certain area where they serve drinks to the high rollers in the casino, and the cocktail waitresses don't get it. So here's this sex-segregated environment. So my questions that I was asking is being a sexy woman a BFOQ for being a cocktail server, okay? And if not, under Jesperson's recognition of Price Waterhouse claim of sex stereotyping and dress codes, how should casino employers dress men and women cocktail servers? I came to the conclusion that it isn't a BFOQ. Now, I think that there are good arguments on both sides. I find it very hard to find that being a sexy woman is related to the essence of the gaming business, but it depends on how you define the business. What most casinos would say is the business is entertainment, and they're necessary to the essence or related to the essence of that business. The problem with that is the other piece is, is it really a qualification for their job to serve cocktails to be young and sexy? So, I mean, I think it's really hard. Now, there are these Playboy Bunny cases, though, where the courts, at least in New York, they've upheld a BFOQ in those cases. But more important for me was to ask the question about, well, should it be a BFOQ? Some of the policy considerations, of course, is, anti-subordination of women. We are defining these jobs as subordinating. They're not selling sex as a business. Cocktail servers are the only employees who are dressed in sexy dress in casinos. But the argument for a BFOQ, and this is a policy argument, is that, these are good jobs, as I said, and women make a lot of money. But my problem with it is that, as Vicki Schultz has shown so well, sex segregation leads to pernicious results, and I think that these jobs need to be integrated. So after Jesperson, what happens? My view is that there is no question, I don't think there's any, that casinos intentionally are stereotyping cocktail servers. So if they can't prove a BFOQ, what are we going to do? What are they going to do? How are they going to dress the men? I think they have to hire men. And there are two ways of doing it. You could dress in a unisex code, kind of like the bartenders in the Harris case. But it seems to me that if casinos are concerned that it's going to be drab and boring, really what we should do is permit them to hire both men and women in that job and to sex stereotype them both. And I'm actually serious about this because my sense is what that will do is change how people look at subordination of women. Because the real problem isn't that women are subordinated or the sexiness of the job. The real problem is that it's only women who are sexy, and the customers have this power over the women, and a lot of times they're harassing them. So if you put men in those positions, I think it'll be a gender-bending effect, and will challenge the fact that women are sex objects, women alone are sex objects. Let's see, I have some pictures here somewhere. Okay, what should these uniforms look like? The comfort should be equal. You have to make them equally as sexy. I can't even imagine what they're going to look like. But we'd have to work on that. I don't have enough time to talk about that, but I've got some sort of funny pictures. If I can come up to them, let's see. Okay, there's the Chippendales. A personal story about this is the Chippendales is a show in Las Vegas, and these men show up in the Rio looking like this, walking around. And I walked into the Rio the other day at like 9 o'clock in the morning for this conference, and I saw these guys there, and I was taken aback. And this is what I mean by the gender-bending effect. It made me much more uncomfortable than seeing the women because I'm so used to seeing the women. And I think, their hair is all, they don't have a bit of body hair, and, they're real sexual beings, even though they're exposing the part of men's bodies that people often expose. So, Thunder from Down Under as well. Okay, here's another possible potential uniform. I have to say, Elaine Chauvin, who's now on our faculty, told me I had to put this in. So there's... Okay. And this is on the back of many of our taxi cabs. And one of the most interesting thing to me about this is one of my students told me is that one of these is a man. You can figure out which one it is. And actually, evidently, it's true. It was in the news when everybody has their theory. Thank you.
Well, should we just go? Go ahead.
Well, Ann has talked about gender differentiation in uniforms. We're going to talk about it in the context of body art work rules. More and more employers now, as more and more people have tattoos and piercings, are putting into place body art work rules that address tattoos, piercings, and other forms of body manipulation. And we look at it from a number of different perspectives, including gender differentiation. And a lot of what the courts often discuss is this notion of social norms without stereotypes. So we wanted to figure out what were some of the stereotypes regarding body art. And we went back into history, and I know that Jeanette and Ryan said they learned a lot from our article, and I learned a lot too in doing the research about where some of the negative connotations, because in the US it is primarily negative, come for tattoos and piercings. And we contrast that with other global cultures where tattoos and piercings are part of high status behavior and are viewed as, spiritual context or group identity and viewed in a positive way. But when we looked at it in the US, we saw disturbingly, it was really based on the fact that tattoos were found in outgroups, people who were generally considered to be lower status. And it was stereotypes based in race, ethnicity, gender, and class, things that I didn't necessarily know before I went into this research, to try to find out why people sort of have sometimes an aversion to a person with piercings or tattoos. And we found in the research that primarily tattoos are encoded as masculine, a form of aggression often found on military personnel, but also found in outgroups like prisoners and bikers and members of gangs. For women with a tattoo, since you're taking on sort of a masculine code, it was viewed as a form of sexual availability, which we were kind of fascinated by. For the women, it always had to be sexual, no matter what it was. So it was sexual availability and a linkage to prostitution. When you looked at piercings, though, particularly piercings on the ears, it was viewed as encoded as feminine, because it was the notion that women should be decorated, part of this notion of pleasing the man that Anne talks about in the casino environment. This form of decoration is part of women being kind of sexual gaze objects. But when a man wears a piercing, some people get uncomfortable because they're not, as Anne pointed out, not used to seeing men as sexual gaze objects, but also because it challenges some of the notions of what is masculine and what is masculine behavior. So we analyzed in our paper a lot of the cases dealing with body art work rules, and we looked at it through the lens of Title VII. A lot of these cases had been brought based on race, based on gender, based on ethnicity, and based on religion. And generally, we found that the court said, and we've talked about performative acts and identity earlier today regarding race, that if it was race or ethnicity, too bad. It was a voluntary act. It's not biological, it's not an immutable trait, therefore the courts would not protect it under Title VII. And even in cases of religion, it was fascinating. The courts oftentimes want to say, it's a personal preference. It's really not something you have to do. So they looked at biology and said, well, if it's not natural, therefore the employer and the law doesn't have to protect it. But when we look at gender, the picture is much more mixed, because of the fact that having a piercing or a tattoo isn't biological or natural when it comes to gender. But what the court has done is says, well, let's look at the social constructions of gender and say that's what's natural. How society views gender, that's natural, and anything else is artificial and aberrant. When we looked at the body art work rules cases, it was fascinating to us that when it involved tattoos, employers were required to treat men and women the same. So it was the notion that if you were a woman wearing a tattoo and the employer allowed you to have a visible tattoo, well, that was fine, because in a way it was a step up. You're taking a masculine trait, so that's a good thing. But when it was piercings with men, well, they went crazy. And I always loved the Willingham case where they talk hysterically about, if we let men have long hair, next thing they'll have earrings and dresses, and oh my God, the world will end as we know it. It hasn't ended yet. I mean, we're still evolving now in this room. But a lot of it is this notion that if you have piercings and allow a man, you are disrupting the norm. And that men are allowed, or basically are told, you have to perform your masculinity. Women will give you a range of conduct. You can be feminine, you can be masculine, but if you're a man, don't dare be feminine, because that's the ultimate insult to your gender, is to take that step down. And so Jennifer's going to talk a bit more about this in the context of performative acts and gender marking.
So I brought to the table no experience in legal theory, but cultural theory issues connected to gender performance and gender marking. And in my field, Judith Butler is sort of a rock star, very famous. But I'm not sure that everyone here is familiar with Butler and what she argues. Essentially, if you're directing this at first in a classroom to undergraduates, the first thing you say to them is there's a difference between sex and gender. And they keep using the word masculine and feminine interchangeably with male and female. And Butler, of course, points out that you're born with a body. It's typically, most often, a male or a female body in a biological sense, and then gender is encoded upon you. So masculinity and femininity is learned behavior. You are taught how to be masculine, taught how to be feminine in a cultural sense, and you learn certain kinds of acts that are associated with that. So we looked at this issue in terms of gender performance, and the tattoo and earring case was kind of fascinating to us in terms of another set of issues, gender marking. And there's a woman, Deborah Tannen, and here we kind of connect to the people from the last panel, Ashley and Laura, talking about organizational behavior and assumptions about marking. And the marking issue is intriguing in this case. Tannen says that dress and grooming choices are never neutral, that which has been deemed the baseline of grooming and appearance standards in the workplace, quote-unquote professional appearance, the dark suit, flat shoes, short hair, and the absence of accessories, is actually the reflective of a bias towards white, heterosexual, middle-class, masculine appearance. And that women, as well as racial and ethnic minorities, are always considered to be marked. So that great example of taking the white colleague to the church was a moment in which that person had to face that in most of his life he was privileged, and he didn't have to think about himself as an other. But that what gender marking in the workplace is interesting in terms of grooming is the dress issue on the man suddenly makes him marked by gender. And normally he's just unmarked. He doesn't have to think about his choice because his choice is the standard. But the standard choice is a biased choice. It's just not thought of that in our culture because it's accepted as the norm. So Tannen says that women are particularly always marked because every choice they made is read in terms of their femininity. So whatever hairstyle you have, there's an assumption about where you fit on a continuum of femininity. And until these earring cases and the long hair issues with men are assumed to not have a range of masculinity. There's just one way of being masculine. The interesting thing for us is the male earring wearer, once he puts the earring into his ear, he puts the tenuousness of the construction of dominant masculinity on display. He makes people have to think about what is masculine when normally it's unmarked. So he marks his body by gender, and then he calls attention to the gender of the other men, the gender performance of the other men in the room, and that they're performing something. And this, we think, is a site of anxiety, not just in terms of issues about masculinity, but the fact that corporate power is coded in masculine ways. So what's put on display also is that corporate power and the way that it's conceptualized is also unnatural, that it's something that is created, and that the organizational behavior group was kind of talking about this, that somebody created the organization and created the behavior in a certain way, and it's been accepted as just a natural expression of something, but it is a created cultural construction. And so for us, the male earring case was really fascinating for that, and the anxiety around this earring-wearing person in the workplace, and how he was making the other men's masculinity be on display and a source of anxiety, when typically it was only women who had to be anxious about gender issues. The other interesting thing is when the women were allowed to wear the earrings and allowed to have the tattoos, we thought also that it was connected to an anxiety about assumptions about women's status, and that's kind of connected to what you're saying, that once you put the man in the sexy outfit, it makes you think, well, why are women only objectified as sexual objects? Why can't men be objectified? Or why does anyone have to be objectified? That, or just at least it puts it in the conversation. It marks it. Suddenly it's not just that women naturally should look this way and be servers and be sexual, but that we culturally construct them that way as opposed to that they're naturally that way. So I love the idea of putting the men in the outfits too. And I think it might be good for business because more women travel in groups now, so maybe it's a good idea. Business-wise, you want to bring that back. But not that little contraption the guy at the beginning. I don't think women would like that. But also fascinating, of course, is that the tattoo. So why can the women wear the tattoo? And it seems like if we were I teach film theory, so I always think of these things as like moments in films. And there was a moment in Wedding Crashers about a female tattoo, and the moment on Saturday Night Live about female tattoos on the lower back, and that they're called tramp stamps. And so I looked at the tramp stamp, there's a tramp stamp website, and I found that it is all women on the website, and it is all that lower back tattoo. And the assumption that somehow that tattoo is marking them as sexually available in some way, but also just reconfirming their status as subordinate. So perhaps the tattoo is not a problem for women because that just reaffirms their subordinate position in the workplace. Just makes them less powerful, so it doesn't matter that they wear tattoos. So we looked at a bunch of these tattoo and earring cases, and we thought it was kind of fascinating that employees are most often given a gender performance review along with their performance review. And the most desirable employees in this environment are the ones whose gender performance complies with social expectations. So playing on that idea of how are you a complying employee? And if you comply with social expectations for gender, you're the most acceptable employee. That's all.
Well, this is an awful lot of fun for me. I usually don't get to leave my office. I'm sort of attached all the time to my word processor, which is what we appellate lawyers do most of the time. Once every couple of years, you get to do an oral argument, but most of the time, you're locked up in the office. And for those of us who do impact litigation, and I'll say this specifically to the law students that are here, I think it's something we always try to keep in mind is that we're working for a certain type of progress on issues that we think are really important, and we need to keep in mind that when we learn about test case litigation or we learn about issues, things often collapse down to a particular case that represents a principle. But they actually take place in a much bigger social context, and the Jesperson case is certainly an example of that. There's been work going on, and Anne would know this, to try to improve working conditions in Nevada and in many places, conditions for working women, and to try to erode the sort of role of sex stereotype rules. It's been going on for a long time, and it will continue. There were many things about the decision that we got in Jesperson that are disappointing, but I have to say, I feel like we moved the law forward, and the fact that these conversations are going on and this conference is happening, and that it sparked some thought on these issues, that is a lot of what we try to achieve when we look for cases that can present these important issues and get people thinking about things that otherwise get taken for granted. Let me acknowledge something that I think has been alluded to here today, but I want to put a spotlight on it. This is the kind of case that I and some of my colleagues at LAMDA Legal had been looking for because we work to try to provide greater legal protection and security and room for gender variant people, for queer people, and to use the tools that we have to try to challenge some of the restrictive rules that have a particular impact on gay, lesbian, bisexual, and transgender people. So it wasn't an accident that when I got the call from Darlene Jesperson, I was really interested in the case. We'd had lots of discussion about potentially useful and potentially not successful ways to work within Title VII and Title IX, and ideas about gender stereotyping to create more protection and also to sort of deal with this strange cabining that we have in the law between sexual orientation cases and ways that those had not been successful, and sex discrimination cases, and the way that the theories overlap in the lives of people, but we have this legal doctrine that, in order to move things forward, creates cabining. Even though we all recognize, and judges recognize, that there's something artificial about that, and yet it is really important, and I think we've had to focus on being able to say, look, just because a person may be experiencing a certain type of discrimination based on their sexual orientation, that doesn't mean that they're not experiencing at the same time sex discrimination, and that we need to talk about what gender identity is and get people recognizing that everybody has a gender identity. It's not just transgender people have a gender identity and everybody else, doesn't. So and an important part of the challenge that we've had in a lot of these cases, and again, this has been mentioned today, is how to deal with the way courts and not just courts, but people in society generally, I think often consider some of these issues to be trivial, while at the same time having deep attachments to what feels comfortable. So if a woman, for example, challenges the idea of makeup as a requirement, she's being silly, she should just do her job and stop creating a fuss. And yet the resistance that her argument meets is often a reflection of the fact that people actually, these issues really matter a lot to people. And so, it's trivialized sometimes, I think, because it goes pretty deep and people don't necessarily know what to do with it or how to justify things that seem so basic. There were ways in which the Jesperson case was perfect for trying to address some of these issues, and I say this from a litigation perspective, because it's relatively unusual that you have an employment discrimination case where you really don't have disputes of fact. The policy was clear on its face. Darlene's employment record was quite stellar. There really weren't any disputes about why she, that she had to comply, refused to comply, and her job was terminated. That's really quite unusual, and it created the opportunity to really talk about this rule that was imposed on the women bartenders. I do think there's a curious thing that I don't have an explanation for. I have some theories about why some of the women's rights groups weren't interested in the case, but the LGBT rights groups have been interested, that I think, reflects some kind of important ideas about what's considered important for working women, what's considered a burden. The question came up earlier, so interesting that there isn't any information in the case about Darlene's sexual orientation. Well, she's a lesbian. She wasn't fired for being a lesbian, and it was very important to the way the case was being put forward that her sexual orientation not become an excuse for the court to not take seriously the sex-based restriction. But I think the reality is that it's lesbians and other queer people that often care a lot about this particular type of restriction because people have less of an ability to conform to that particular stereotype. According to what Darlene tells me, and I wasn't her lawyer at the beginning of the case, there were lots of women at Harris who really objected quite deeply to this makeup requirement. But she was really the only one who was willing to give up her job for it. And that was really because she didn't feel that she could comply with it, and other women did, and that has a lot to do, I think, with her sense of her own gender, and so she fought it. In a sense, she wasn't situated the same as some of the other women who did comply, because she really just couldn't. As we were preparing the case, I think we expected a lot of the questions about what about men in dresses, and put some effort into creating what was to be the principle that I think it does resonate a lot and comes out of the Title VII case law, that Title VII is about opening up opportunities and dealing with subordination of groups. And so if you have an appearance rule that tends to subordinate or sort of demean the professional status of a group, that you can look at that more rigorously and demand an explanation for that in a way that may not apply if you have a rule that doesn't subordinate by groups. And so, there was sort of an attempt, which was partly a litigation goal, but I think has some bearing to it, that a rule requiring men to wear ties that marks them as men in a business environment doesn't necessarily have the same subordinating role that it does to require women to show their legs or alter their appearance with makeup. So those different rules aren't necessarily parallel or equal in terms of the effect in a workplace. But what I found surprising and really troubling was that in some of the oral argument, both in the three-judge panel argument and then in the en banc argument, we didn't really actually get to what I thought was going to be some of the harder questions about distinguishing rules about men, because some of the judges got stuck at the first level of, well, what about a woman who won't shave her legs? And what about women who won't wear skirts? Which I'll just say a brief anecdote. I found that one particularly hard to take because I was arguing the case wearing a pantsuit, and the lawyer arguing for Harrah's was a woman who was wearing a robin's egg blue skirted suit and high heels. And the judge actually who asked that question was appearing by speakerphone, so I think he didn't quite appreciate the irony of his question about whether law firms should be able to fire women who won't wear skirts. But, I think it is, I mean, one thing I believe has happened and I hope has happened is that the case has prompted some of these questions to get a different level of attention, and the fact that, that Judge Schroeder's opinion has opened the door for future cases, although creating some evidentiary questions that, as a litigator, it's sort of curious, well, how will people exactly proceed to make that evidentiary showing? But at least the door is open that some of these questions can be asked, and employers who have different rules based on sex will have to come up with some explanations. Guess the last point I'll make, and I'll be interested when we have our discussion about the different sorts of questions that people have, but is to just sort of focus that in some of the earlier discussion earlier today was to look at things like, well, so what about a person who wants to wear scent and they're working at a natural food store, or, or tattoos, or some of the other things that an individual employee may want to do. I just want to draw the attention back to the idea that Title VII is about a particular type of problem in the workplace. I mean, I would agree with the comment of earlier today that it isn't a tool for dealing with everything and for creating equality in terms of a lot of different important individual employee needs. But it is about requiring a good reason if an employer is treating people differently based on these characteristics that are covered by the statute. I mean, one of the ironic, perhaps, and really sort of disappointing elements about the case to me is to have judges who, by their history, one would think they would describe themselves as conservative, and they were appointed by presidents who were looking to sort of conservatize the bench. People have talked about that as a sort of strict constructionist, don't make the law, apply the law. Well, Title VII is very clear. The plain text of the statute says that employers can't be imposing different rules based on race or sex or religion or national origin. And so if an employer is imposing different sorts of rules based on sex, then that's what needs to be justified. And the point of the case was the message that women can be professional and Harrah's can have a look that's branded and recognizable with employees who are well-groomed without requiring that the women and only the women alter their face in a prescribed way. Because it's imposing a rule that's different for women and men. The reason that we put the photos on the website was to reinforce the point that Darlene was not a cocktail waitress. She was a bartender. She was dressed the same as the guys. She was doing the same job as the guys, and she did it really well. There was one job description, and she was performing that job description, and she wasn't allowed to do it as a bartender. They were requiring then that she be marked as a lady bartender, as something that was different than the guys. So the attempt was to visually reinforce the idea that this was really a Price Waterhouse case. She was doing a job in a male-dominated profession or part of the workplace with the same uniform in the same way, and they were requiring that she be marked as different. So there's, I think, an interesting little, it's either a parallel or a contrast, and being a litigator and not a theorist, others may look at this differently, but the previous speakers who were talking about the problem with requiring racial assimilation or one standard that's, of course, a white standard that everybody needs to conform with, there's, I think, an interesting contrast here that Darlene was trying to assimilate. She had been assimilated, and they were requiring that she be marked as different from her peers. And part of why, that idea of being part of a team, whether it's a branded team through a uniform or whatever it is that makes a team, she was being required to be different, which changed her role from just being a bartender. And that was one of the big problems for her.
Well, in light of the slideshow that we saw earlier, I have to say that I thought about doing a PowerPoint, and the only reason I wanted to do a PowerPoint was to do one slide, which was of a pair of a particular species of bird that has just a name that so would be so appropriate. And can anyone guess? The birds are great tits. So I was going to have the slide and make a joke, but I thought, oh, it could fall really flat and that would be bad. So I decided not to do it. I'm glad that I decided not to, because I think maybe it would have fallen flat. But in any event, I appreciate Professor Fisk's comments about biology, and I recognize that that sociobiology, evolutionary biology, whatever term we choose to use, is a fraught field. Certainly when we try to import some of these ideas into the legal arena, it's extremely fraught. And yet, I think that there are some concepts, either some empirical work, some theoretical ideas, or even just metaphorically, some ideas that are powerful and can give some insights, especially into gender difference, sex difference, and performance of gender identity. And so one thing that occurred to me after listening this morning to Professor Urako speaking about reification is a study that was done that I think is very interesting on fruit flies. Fruit flies are used frequently because the generations are quick, and so they evolve very quickly. And I heard a lot of evolution metaphor this morning. A lot of people talked about hoping that gender norms would evolve. Evolution is an extremely powerful metaphorical concept in law. But so in this particular study, which I think is really interesting, what the scientists did was they, male and female fruit flies and other species, they co-evolve. And so the males evolve something to be more reproductively successful, and then the females evolve something sort of in return that allows them to be more reproductively successful, and it's a sort of an arms race. And so what happened in the study was the scientists held the female fruit flies steady so that they couldn't evolve. So they kept putting the same generation one of the females in, but they allowed the males to evolve. And what the fruit flies do is they have sort of chemical weaponry, and so the male fruit flies in their sperm, in their semen, they have chemicals that allow them to be more reproductively successful, either by killing the sperm of the other males, because fruit flies are somewhat promiscuous, and so they'll mate all around, and so these males want their sperm to be the one that fertilizes, and so they evolve these chemical weapons, and the females co-evolve to protect them from the weapons. And what happened in the study is when they kept putting the females back in that were generation one, after a few generations of male evolution, all the female fruit flies died, because they could not protect against the stronger and stronger chemical weaponry of the males. And so I'm not sure what insight that sort of analogy has to offer, but it occurred to me when we're talking about courts and companies sort of reifying social stereotypes of gender and holding them steady so that this evolution can't take place. So that was an aside. And then, so for the 2 points I'd like to make this morning, though, are that I decided to look at this because it seemed so sort of clear that there are dress differences in many animals, and the peacock being the paradigm. So I chose the peacock as the title. And so the peacock, wears this very fancy dress. We can think of it as dress. There are some animals that their dress is more behavioral, like these bowerbirds that decorate their nests, and certain species choose certain colors because the females like the colors. So one species of female bowerbird, they like blue, and so the males run around finding all the blue things they can find, and they decorate their bowers, they're actually not nests, they're just a mating place for the birds. So there seemed this obvious difference, and there were a couple things that seemed interesting about it. And one was that the pattern seems very different in humans as opposed to animals, non-human animals, because in humans it's typically, in contemporary Western society at least, it's the females that are more highly decorated, more colorful, more adorned. And in animals, the general pattern is the opposite. So that was one thing that seemed interesting. And so I started to look at this comparison, and a couple of main things jumped out. And one was that dress differences, the courts typically view them as trivial, and Jennifer talked about this a bit, and I completely agree. Courts see them as trivial, and yet the animal sexual selection literature strongly suggests that differences in dress, differences in appearance between males and females are not at all trivial. In fact, they're exceedingly important, and they come about because of sexual selection, because of the social gender sex context in which they evolve, and so they're not trivial. And these dimorphisms are completely crucial to the interaction, the mating, the reproduction, and the evolution. So the first thing is that sex and sex differences, sex is a very salient trait in biology, in evolution, and it continues to be salient even though it seems trivial. And another point that I noticed was that in the sociological literature on dress, and even it comes up in some of the cases, this idea of fashion, dress, adornment as trivial is strongly associated with women. So women are interested in fashion, and women can't be professional unless they wear a uniform because they will compete with one another to wear fancy clothes and whatever, and they'll be business inappropriate. And so I think that the very notion of the triviality of dress is a sort of stereotypical, feminine, demeaning sort of notion. Another point about the triviality is that so many biologists and many people think, the peahens are being silly. Sort of in evolutionary biology, there's a lot of discussion about why. Why do they prefer the fancy tails? Why are they doing that? Well, they're just silly. They just like the colors. They're like women. They're like silly women who like dresses. And what the empirical research turns out to show is that, in fact, they're not being silly, and in fact, they are choosing, though we don't exactly know why. They're starting to figure out why. We don't exactly know why, but in fact, they're choosing the best genetically fit males. Something about the way that the females are preferring the males with the colorful tails, they're right. They're picking the best ones. And so I thought that was a very interesting sort of idea. I'll make one more point because I don't want to take up all the time. I want to read the description. The most decorated male animals are in species that are called lekking species. And in these sorts of species, what happens is all the males gather in what's called a lek, and they display. And the females walk around, and they decide who they're going to choose, and then they choose. And so it's clear in the biological literature that these are the species that become the most fancy. So birds of paradise and peacocks, these are all lekking species. And I just want to read a description of a lek of the sage grouse, which is a species of bird, because I think this is so great. This is a description that comes from a science writer named Matt Ridley. And so he talks about going out and watching this lek, and he says, it's an extraordinary experience to drive out to the middle of Wyoming before dawn. stop the car on a featureless plain that looks like every other one, and see it come alive with dancing grouse. Each knows his place, each runs through his routine of inflating the air sacs in his breast, and strutting forward, bouncing the fleshy sacs through his feathers for all the world like a dancer at the Folies Bergère. The females wander through this market, and after several days of contemplating the goods on offer, they mate with one of the males. That they are choosing, not being forced to choose, seems obvious. The male does not mount the female until she squats in front of him, etc. I thought that that was really just a great description. What the lekking species do is that the males only contribute genetic material. They contribute nothing else. And those are the species in which the females have the greatest degree of choice. The males most highly decorated, the females have the most reproductive autonomy. And so now flipping it to look at humans, here we have the human female as the most highly decorated. And what does that imply about choice and autonomy and power? And that was a sort of the greatest, I think, insight that came out of looking at non-human animal choices. I'll stop there.
Okay, so Tristan Green reminded us earlier that the basic point of Title VII is to promote a certain kind of social equality. And so the question I want to ask is, what exactly is the equality objection to sex-dependent restrictions on dress and grooming? And I think in answering that question, it's useful to distinguish between two types of restrictions. One kind is kind of the naturally evolved social conventions pertaining to dress and grooming, things like makeup requirements, truly conventionally gendered restrictions on how people are to dress and groom themselves in the workplace. And on the other hand, sex-dependent restrictions that might be seen as more artificial or ad hoc and not sort of organic in the same way. So, for example, a requirement that men wear green shirts and women wear blue shirts. Now, I mean, I'm not sure that there ever has been such a requirement, but it's at least possible to imagine that. So at first blush, I think the former kind of restriction seems more problematic from the viewpoint of equality, because it's hard to think of how these social conventions came to be without thinking of the history of sexual subordination and substantive material distributive inequality and so forth. It's all tied up. And so those social conventions, when they're reinforced by means of workplace restrictions, seem obviously problematic from the perspective of equality. But what about these sort of artificial sex-dependent restrictions? They seem kind of silly, but not so clearly objectionable from the standpoint of equality, because it's harder to tell a story about how that kind of restriction could lead to substantive, material, distributive inequality. But on reflection, I mean, I think these kinds of restrictions force us to tackle, to me, a deeper conceptual problem about sex-dependent restrictions. And my sense is that most courts would think that the requirement that women wear green shirts and men wear blue shirts is fine. Or I think I said it opposite before, but my sense is that courts would think that that's fine. But what that implies is that rather starkly, the bald claim that an employer is allowed to distinguish between the sexes, even when there's no particular substantive need to do so. It just can do it because it wants to. So my question is, if the law does permit this, what general principle is implied? In other words, what principle are we committing ourselves to if we agree that it's permissible for an employer to make these completely artificial distinctions between sexes? And my claim, I think, is that the permissibility of these types of artificial restrictions implies at a minimum that there's no institutionally authoritative principle that forbids attempts to constrain behavior in one way or another on the basis of sex. Right? If these kinds of artificial restrictions are allowed, then that implies that there's no institutionally authoritative principle that says you can't make this kind of distinction, right? So the ultimate question for me is, why isn't there such a principle? I mean, after all, in the context of race, right? If we had a workplace restriction that said Asians wear orange shirts, Caucasians wear gray shirts, I mean, that would just seem clearly objectionable. So that there does seem to be at least a stronger institutionally authoritative principle that says you can't just draw random restrictions based on race. So why isn't there that same kind of principle in the context of sex? And, I think that the question that we ultimately have to face is that, the law seems to assume or presuppose that there is some kind of a positive social value in maintaining this sort of linkage between gender and sex, right? And for me, if there is an objection to these, what I've called artificial sex-dependent restrictions, then that question has got to be where the real action is. If those restrictions are objectionable, it's got to be because there's no social value or overall a negative social value in maintaining this linkage between biological sex and constructed gender. I don't have an answer to whether there is such a social value or whether there's a negative value on that, but the point ultimately of my paper is that that's really where the action is.
Okay, Martha.
Patrick, with the shirt example is such a good one, because my first reaction was, of course, the law does forbid that, and that would be segregation. Just to introduce another concept that is explicitly written into Title VII, and to connect that term with this judge-created exemption for grooming requirements. It seems that the concept of segregation was exactly that, to get at any kind of separation that was there solely to mark people as different. I mean, it really is, in that sense, very much the child of the civil rights movement, and how far we've gotten from that concept of segregation. And now I think we think more about segregation as either a physical separation or a denial of an opportunity to advance into a different job, the kind of job hierarchy that, of course, was enforced through segregation. But I think it's important to kind of revisit this notion of segregation. And I wanted to think of those instances where women have been required to wear a different color than men. And one thing that always really pissed me off was to go to these high school graduations at private high schools where the young women would be dressed up like brides, wearing white dresses, and the guys would wear suits. And why we would want to segregate graduation at a co-ed institution was, of course, just for that reason. So I actually agree with your analysis about that's where the action is. I think a court might be a little more inclined to resist this notion that an employer could require its men and women to wear different color shirts.
That's interesting. I guess I was assuming the doctrinal approach of Jesperson, which clearly there's no greater burden, wearing a green shirt as opposed to a blue shirt.
Yes,
so.
but of course, what is a grooming requirement? I mean, that isn't something that it finds its way into the statutory language. I mean, the word segregation does. So playing with that versus the grooming requirement, I think, has some purchase, at least as a doctrinal and tactical measure. Paul?
Thank you. I wouldn't be allowed to go home if I didn't have the opportunity to respond to some of the things you said. I have a list. We do have male cocktail servers. They are few and far between, but I suspect they're hired in greater percentages in terms of ratio to applicants to hires than females are, because it's a job that's, frankly, in newer casinos, very, very sought after.
Can I ask you how you're dressing them?
Not like you had pictured. We've tried to create an analogous, a uniform that's analogous to what the females wear. And again, people can debate whether we've done that successfully or not, but that's the goal. We don't pay for implants. We don't encourage implants. There was an issue about a reference to bever Cainers at the Rio Casino. That's one that we own. And that an assumption that, one, cocktail servers were asked to sing and dance in order to fire all the old ones, and two, to break the union. Both are absolutely false. As far as the union, the cocktail servers were not unionized. Harrah's is a very union-friendly company. In most cases, we welcome unionization, and it's ironic that that claim was made because I just finished negotiating a contract for hundreds of employees represented by the Teamsters Union at the Rio that we voluntarily recognized and we welcome. So there's absolutely no basis to claim there was any effort to break the union. They weren't unionized before. As far as hiring all the old ones, no. Firing all the old ones, no. As you said, there are newer casinos that are hip and have more high energy, and having them sing and dance was an attempt to make the Rio more hip and high energy. People could say that it succeeded or that it failed miserably, but that was the motivation. We have no weight requirements. We did purchase a casino earlier this year that did have a weight requirement, weigh-in requirements. We immediately suspended that. And we have appropriate uniforms for pregnant cocktail servers at that property. And I know there was some litigation regarding pregnancy at that property before we purchased the property. I guess as to the comments on the litigation, I guess we have one factual dispute, Jennifer, wasn't in the record, and that is that we knew of no one who complained about the makeup requirement other than Ms. Jesperson and perhaps one other person. And I don't work in human resources, but I can tell you that, of course, people are hesitant to complain to the point, can't complain to the point of giving up their job. They're very hesitant to complain about conduct that implicates misconduct by supervisors. They fear retaliation. But in my limited experience at our properties, they don't hesitate to complain at all about work rules that they don't like. They may not take it all the way to resignation or termination, but they don't hesitate to complain about work rules. And we didn't get a single one that I know of. So we do have that one factual dispute. The final thing I wanted to say, as far as the dresses, if you're going to have a rule where every sex-specific appearance standard has to be a BFOQ, I'm not sure how you can prevent males from being permitted to wear dresses and high heels at work. And Harrah's doesn't care in the least whether they wear dresses or high heels. Harrah's does care whether they wear their appearance is such that it distracts from the business we're trying to conduct. Just like the person wearing leather at Whole Foods. And a male wearing dresses and high heels would distract, at least in Las Vegas, customers from doing what we want them to do, which is eat, drink, and gamble.
Can I just make something clear? I just wanted to say that I wasn't gearing all my comments, or any of my comments at Harrah's, and Harrah's actually has recently acquired a number of the properties that we were talking about, and I think is changing some of the things for the better.
Jenny?
I think it probably is true that some of what you've heard, having joined Harrah's more recently, may be a little different from what Darlene reported as her experience when she was working there. I think we can probably definitely agree that there might be a difference between how many objections are reported in a formal way that gets captured by the company versus what employees experience but don't want to put their jobs on the line about. And one of the things that I believe I saw documents in the record that is sort of an example about how a weight rule, for example, might look different from the employer's perspective than from the employee's perspective, was that when the personal best program was put in place, and this is, again, it's according to the documents, I wasn't trial counsel, but there was a rule that employees had they were given a uniform when they were hired, and that's the size they had to stay. And if a female employee became pregnant and had a child, then there was a quite short period of time in which she could then get back to that size, but she had to get back to that size. So you don't need a rule that says you can't gain X number of pounds if the rule is you have to fit in your same uniform. But in any event, I mean, I think the same thing might be said also about some of the perceptions about what's union-friendly and what's not union-friendly. But I think that the bottom line that I would just reinforce is that Darlene had no objection, and certainly from my perspective as somebody who cares a lot about these issues, it's not an objection at all to the idea of a company trying to develop a branded look, and that a company would have the right to create elements of a look and to change the look. But if there are sex-specific requirements, that those need a justification, and that, I mean, and I think, that, as I said, the principle that we articulated in the case, which I think is right, is that you can distinguish between rules that require women to change their appearance, and in particular, to undergo a complete makeover. I mean, that's one of the things that's sort of interesting about this, is that it wasn't a requirement, and I've had numerous debates with colleagues of yours about whether, was it a little makeup or just some makeup. It was a complete makeover done by a professional that the employee then had to match every day to meet a picture. So it was, there may be many things about Harrah's that are employee-friendly. I don't know the full range of things, but that's a makeup requirement that's more specific and burdensome than any I had seen any other place, which seemed therefore to be an appropriate vehicle for sort of calling the question about whether women can be required to change themselves because they're not good enough being themselves, and that is different from a man wanting to wear a dress or objecting to wearing a tie if those rules about male appearance don't involve the same, or at least arguably, the same subordination of men as a group. Now, what that means for a man who either identifies as trans or somebody who's doing a transition or wants to not identify as either male or female, that's definitely a more complicated question. But if you talk about women and men and rules that treat them differently as a group, I think you can absolutely have a workable distinction, and I would hope that Harrah's and other companies that have thousands of employees would think twice when setting up rules that require, in particular, women to conform to, quote, traditional ideas that require skirts and heels and so forth. So that aside, the point that I wanted to make in response to what Patrick was saying, I mean, we used the colored shirt and, issue in the briefing, and I think there's an issue that could just be unpacked a little. There's, I think, a harder question whether you can justify requiring women to wear, say, yellow shirts and men to wear green shirts. It should be an easier case if you're requiring all the women to wear pink and the guys to wear blue, because there's some content to what those requirements are. And that's part of what we were getting at, is that that if there is an assignment of a role where there are social understandings that go with that Title VII more clearly has something to say about that, and that can interfere, and it can interfere in different ways depending what the job is. If you have a woman doing a job in a traditionally male occupation, but she's required to wear pink, then it's sort of like, okay, so fine, she's working on a construction site, but she has to have a pink tool belt. It's marking her as different and also in a trivializing way. If it's a traditionally female occupation and she's being required to wear pink, it does something different. And that's what seems like the surprising paradox of Schroeder's opinion, that says that in some ways it may be easier to challenge the requirements of the cocktail servers because they're more stereotyped, even though that's a sort of a more traditionally female job, than the requirement that somebody who's wearing a tuxedo should have to wear makeup and be marked as different in that way.
I saw one other hand. Was it you, Mario?
It was, and it was a question for Patrick. And I just wanted to ask with regard to the analogy you made. And my question is, when you're talking about the race example, at least with regard to the appearance codes, the issue is typically that the court is rejecting that whatever difference the plaintiff is complaining about is actually being regulated based on race, right? So they're typically, your braids are just your hair, they're not your race. And so in that instance, the court's never really getting to any question about the significance of race's difference marking, because if they did, I think you would be right, and then they would say there's no reason to have such a rule. But the problem with, the difference with the gender cases is that the law accepts the gender difference as a normal social division already. And so what they seem to be doing in these cases is then line drawing, right? Deciding how much of our normative stereotypes can we bring in before it becomes oppressive or sexist. And most people who think about Jesperson in that way simply who disagree, think they drew the line in the wrong place, right? Because we have a normal amount of sexism, we're willing to deal with that work, but should it be that much? And so what happens, just as a function of talking about those two categories, is we never are getting to the second inquiry with race, because we're never passing the first hurdle of talking about the difference as a racial question.
I think rather than allow Patrick, or indeed anybody else, to chime in, I'm going to make us eat, and then we'll resume our discussion at 2 o'clock. Thank you, everyone. Oh,